YouTube, it's Tone. I'm back with another one for you, and this one is the last video on the Core Survival. So this is the book Core Survival Guide, and let's get right into this. So this is talking about the penalties that they put against you and things like that. You know, working your way toward different motions and litigation in court and things like that if you weren't able to reach a resolution initially. So here we go. Penalties against you, and the only way to prevent people from knowing God's truth that you have discovered is to murder you. To murder you. So, but what is it? Slavery and death, I think, is the same thing anyway. So as you can see, this is a desperation strategy, because you have already allowed them to take advantage of your inexperience, innocence, and or ignorance. They have forced the judgment of the guilty upon you, using the corruptions of their system against you. Let the judge know that you will not give your consent to being sentenced, and that he or she is obliged to instead find a legitimate procedure to resolve the charges against you. The judge will be thinking twice about pronouncing sentence. You might even win by getting the case suspended indefinitely, because you have exposed the fraud that they must use to penalize you. So strategy 1, plead broke. So this helps you regardless of which way you decide to go. Tell them up front that you are sorry, but you have no money to give them. You are an indigent and you simply cannot afford to pay any of their fines or tributes. Tell them that you understand that the whole exercise from the very start has always been about taking your money under color of law. This lets them know that they have very little to gain by harassing you at penalizing you and penalizing you any further. They know that you know how fraudulent that they are. Strategy 2, ask for retrial. This is what to try for if you feel like you could do much better to win the game a second time, and you can definitely identify and document specific defects in how the court handled your case. When you ask for a motion, when you ask for or motion the court for a retrial, it may not be granted, but it's worth a try, because the extra time and because you might finally win. You might have to schedule a separate motions hearing to present your reasons why you should have a retrial. Make sure one of the motions asks for a stay of execution on your sentence and fines. This is a strategy to be used before you decide to appeal. And that's so you wouldn't actually have to be sentenced or deal with the actual sentence until after the appeal. So if you make it clear that that's your intent initially, then that should be the case. A stay of execution, which basically means to put it on hold. So strategy 3, appeal the case. This is the best plan if you want to hang in there and win the game, especially if you feel you have a good chance to expose the unfair treatment you have received by the lower court. So the good news is that you can defer the payment of your sentence and penalties for a long time until your appeal is resolved, and this makes the court work even harder to steal your money. Plus, because of all the fraud in the lower courts, you are more likely to win your appeal. This is because you will be placing in evidence, at the very least, all of the appealable issues you placed the judge on notice for during the trial. So, you know, and so you notice the judge the whole time that you plan to appeal, so it shouldn't be a surprise, right? So once you decide to appeal, you do not need permission. It is your right. The judge will give you some time to give your notice. Just make sure that you motion the court for a stay of execution on your sentence and penalties until the resolution of your appeal. The judge may force you to make bail as collateral for showing up in court when they call you. You can hire a bail bond person to guarantee your appearance. So when the person hears your motion, the judge will try to intimidate you with the transcript costs and filing fees, because they will insist that you need a written transcript of all your trial in order to appeal. When this happens, remind them that you have no money, but that you will still be appealing the case. You do not need a written transcript, and the court's original tapes transcripts will do perfectly for your needs, and that you give your permission for the district judge to listen to it. So the judge will be unnerved when you resist paying the stiff fees for the written transcript and for filing, but only because you want to make sure that you lose your money every step of the way. Now keep in mind too that you can always discharge that. So if you can get them to send you a bill for it, you could have them send you a bill for whatever the cost is, and then just discharge that shit as a private A4V. You know what I'm saying? There's 1,000 ways to skin a cat. So then you can politely explain that since the original tape has more accurate information, and that since, what do we got here? since it is the court, not you, which requires an additional written transcripts, then it is obviously the court that should pay for it, because you prefer the district judge to listen to the obviously superior original tape. And this is what I'm telling you: to tell them to send you the bill. It's really not a big deal. So if the judge refuses to cooperate further, then you can file a formal notice of and demand, or a separate motion for transcript provided by the court, in order to expose this tyranny more times before your case can finally be resolved. You will first have to write up an affidavit of poverty and get it witnessed and notarized, then use the appropriately labeled information in the appendix for your notice of demand for natural right to court transcript, and or your motion for a transcript provided by the court. Insist that your right to appeal is being denied its due process unless the court complies. So strategy 4, plead sorry and pay up. This admits defeat but helps you cut your losses and aggravation. The downside is that you had really wanted to cut your losses, but should have pleaded guilty up front at the plea bargain, because they tend to make you pay less if you confess right away without taking up all their time. They always try to penalize you for standing up for your rights, but this way, at least you're not facing additional court costs, transcript fees, emotional stress, and the risk of losing. If you abort the mission now, at least it gets you out of the legal system, right? So you can just take, penalties, fines, and fees, and have them send you the bill, slap that with your stamp, A4V, call it a day. You know what I'm saying? So notice to appeal, because I mean, you do have options. You don't have to fight with these people, and ultimately it's already just commercial. You could just get the bill. So notice to appeal. Your notice to appeal from strategy 3 above is just a single page notice that you send with the same type of letterhead as many of your motions that state of your intent to file appeal. So be sure to include your case number. The court will send you back confirmation that they acknowledge your intent, and the judge will give you so many days and somehow get a copy of your trial transcript and submit your appeal brief. The challenge is to type up your appeal brief without paying the cost in the written transcript you see above. The law says that you must refer to the trial proceedings with particularity when you describe the court's defects and judge's decisions that you are contesting on in your appeal brief. This means that you need to be able to quote word for word exactly and articulate what was said during the trial. Your first preference should be to exercise your natural right to have court provide the transcript fees and as described above. A second preference is to use the court tape recording and notes made by you and your counselors and your transcriptionist to work out your appeal strategy. And so you should always have a court reporter there with you as well, so that way you always have all of your evidence there already typed up. So then you can estimate where on the court record tape to find the exact conversations involved. Then you can motion the court to allow both you and the district judge to listen to the tape under supervision so that you can get the exact conversations used in the appeal brief. It is possible to play the court record into the portable tape recorder, and it would not take too long for you and your bailiff to find the portions that you were looking for. Once you have estimated where to find them, it becomes too much trouble for either you or the court. Then just pay the stenographer the fee for the written transcript and get it over with. That's what I'm saying. So just bring one with you, a transcriptionist, stenographer. So writing and submitting the appeal brief. Writing and submitting the appeal brief. So this is the most effort that you will need to put in to put out to finally win your case, because of all the alternate typing involved. But if you or a friend have a personal computer, then you can easily copy, cut, and paste the common and repeated sections. The good news is that if this is your first appeal in this particular court system, they will not expect you to know how to write the appeal brief, let alone a good one, because all the lawyers carefully guard the knowledge of how to do it, just so they try to keep all of the standard legal information secret and proprietary. So the appendix provides an outline and samples for you to follow. Naturally, you will have to develop your argument and customize your brief to the details involved in your case and the issues that you are appealing. The cover letter states your intentions and reasons for submitting the appeal. The table of contents is self-explanatory. The table of authorities simply lists the legal documents you are using to make your points and conclusions with. The statement of the issues section simply summarizes the relevant legal questions implicated and raised by each issue. Each issue is then summarized in a state of case, which briefly explains why the issue is in question. Finally, under each statement of case is detailed argument supporting your case, followed by its own conclusion. You may even include an optional opposing argument to cover both sides. And I would say that that's probably the best thing to do. Because, I mean, you know, to really win a case, you have to be able to understand it from both sides and then just really be able to hammer home your side. You know what I mean? So the argument is a step-by-step legal and logical description of how the judge's or court's decisions is in error, beginning with a list of legal references, i.e. laws and case decisions, which is common law. The conclusion is a brief statement of which the judge's decisions have been contested by the previous discussion and what ruling you expect from the District Court of Appeals. This should be reversal, not guilty, retrial, try again, or acquittal, cancel the whole show. And the last page of your appeal brief should be in an order form, just like in your motions, but with the new case number issued by the district court. Your appeal brief must be as factual as you can make it. Do not exaggerate or imply anything, and do not use offensive or subjective language. This is all law. So your logic should be emotionless, but very complete, concise, and exacting. You are carefully leading the district judge to the same obvious deductive conclusions that you have reached. You are dispassionately exposing the truth. When you submit your appeal to the court and the prosecutor, the lower court will prepare a list of all the paperwork they think or want the district judge to see as your appeal package. They will give you so many days to review the list or contest it, so make sure that every last shred of court records and paperwork that you want the district judge to see is on that list. You may need to send them or file a letter of deficiency and demand to let them know which missing items that you need to be included. Make sure all of your written motions and notices are included, following up the appeal. So now it is their turn to sweat. You have faithfully exercised your duty as an American citizen to stand up for your rights and face the civil injustice. The district court now faces all your evidence and the corruptions of the fraud of the lower court, and they must resolve all of the issues and court decisions which have been placed in evidence. Many of the county judges have very little grasp of how crooked the entire legal system really is, and it is the district's appeal court job to rectify most of the fraud and corruption. They have all gambled that you would never have the sense, inclination, and wherewithal to bring the case all the way to the appeal, but now they must deal with their false assumptions. Assumptions. So it is just a matter of waiting for a decision once you submit your appeal. Some courts make you wait a long time, sometimes indefinitely, before they decide what to do with the case. Sometimes there's just too much embarrassment for their expected payoff for them to be interested in, and you may be perfectly willing to leave your case in limbo as long as your sentence and fines are indefinitely suspended. So you may also have available the following bonus options. Some state statutes impose a time limit on how long the district judge may sit on your case before deciding. In Arizona, it's 90 days, and if the judge exceeds this time limit, he or she is supposed to forfeit his or her salary for that quarter in which the 90 days expired. The rationale is that since the judge's salary is based on hearing so many cases per year, they should not be paid the full amount if they haven't earned it by ignoring your case. So find out what your state statutes say about judges and their limitations. Rest assured they do not want you to know about this one. If you file notice of default and demand requesting the judge forfeit his or her salary, you have nothing to lose, because even if the judge were now to rule against you, it would be an extreme bias against you, and you can then recuse or invalidate the decision and demand another judge and repeat the process. Taking advantage of such a limitation on the judge could be a guaranteed ruling in your favor. Happy trails. Being in the right. You already know that you are in the right and that the system is unfair and stacked against you, but the facts remain that this is still your system as much as anyone else's, and that you are in it, left to play by whatever rules you are allowed by those who are in control. So there is no point in arguing or becoming militant. You do not need to prove anything relating to ego. By focusing on the truth and standing in it, you maximize your chances of inspiring favorable responses in those around you. And you will soon be a master at this when you can consistently steer the officers, attorneys, and judges with your innocent but revealing questions, so that they will eventually figure it out for themselves that you are in the right. And that and if you beat them over the head with it, they will shut you down and become more militant. But if you can appeal to their senses of worth and respect, eventually they will see that you have helped them learn something of value in how they are dealing with the people. The resolution. So when you are finally done with your case, take pride in whatever the outcome is. You have taken on a brave mission to stick up for your rights in the face of unfairness, corruptions, abuse of power, and tyranny. You deserve congratulations for having the courage to stand up for your rights with integrity, purpose, and compassion for all the people involved and affected. You have played your cards in the poker game to the best of your ability with the strategy of a chess game. And I mean, this is what I'm telling you. So do your best work to cover the risks at every step. You are most likely sharing your knowledge and experience with a smile, and the opposition is most likely coming away with their illusion partially dismantled with a heck of an education. You have done your homework. You have done well in your efforts to win the game, even if you have been forced to lose. Preparation. Congratulations, you have done well to come into and embrace this knowledge. Know this survival guide in and out. Make notes if necessary to clarify exactly where you what you want to adopt as your techniques for each situation, and brush up on your knowledge of its contents periodically. And what do we got here? So to refresh your memory, better yet, get your hands on everything you can find that relates to your case. Spend some quality time in your law library browsing and finding answers and info. Also, be sure to question and verify everything in this guide. Everyone has a different idea of what's best to do something and a different understanding of law, so make use of it. Know your procedure and what your options are at every step without having to stop and look them up before you make any court appearance. You know that you will be facing the professional vultures. You will be prepared whenever the time comes. Pleasant and powerful journeys. You deserve it. And this is what I'm telling you, man. It really is a game. And so you should learn the rules, man. And this is what it is. If you even wanted to take it there, you don't always have to fight, but if you want to, there's options. You can definitely get it done. It's how much time do you want to put into it. You may not have an option, so go ahead and put the time into it. So it is a game of chess. Stop playing checkers with these clowns. That's what I got for you for now. Until we meet again.